Well, hello everyone. My name is Carrie, and I have a video that I wanted to play for you guys today, which was a special request from one of our subscribers. And I honestly have not watched this in quite some time. So I thought we'll watch this video together. I'll do a little commentary on it.
Objection leading.
Who remembers the day that Brooks came into the courtroom and he was especially pissy that day? I mean, was he was ready to start fighting with just a good morning. He had that look on his face. She couldn't even get out her stuff where he starts throwing out a bunch of stuff to her. Um, this actually, I think, was after lunch is when this video is starting. But yeah, he was just major pain in the ass this day.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
I don't remember what was said. I'm sorry, I don't.
All right, we are back on the record. Then appearances are as they were before. State have their next witness available.
Yes, Your Honor.
All right, let's bring the jury back out.
Don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party interviewer on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. We still haven't.
See, just
I
jumped
still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming.
Who did he eat lunch with? That was my first thought. It was like, what? Who did he go to lunch with? We know he didn't go to lunch with anybody. I'm just saying. Somebody, maybe he called somebody. Who knows?
Out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait until the jury's out, please.
What is the military
I ask that
power?
you show that respect.
I will.
Thank you.
I'll wait as soon as that door closes, though. I'm going off. Oh, he's a pain in the butt.
Everyone else can you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking, is
Now,
this...
what legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What What are we in here?
He doesn't know what
And
he's asking.
I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me.
The audacity of this man to even go down this road after everything that the district attorney's office did to get this trial moving forward, because God knows if we were having to wait on Darrell Brooks to do some of the things that should have been done from his legal side, we'd probably still be waiting on the trial today. It just blows my mind that he never remembers any of that stuff. He even acts like they're using it against him, or they have an advantage because they're helping him. It's just the strangest thing ever.
And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor.
Biases.
You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven.
Oh Lord, here we
I've
go
raised
again.
that issue numerous times, pretty
Yes,
much
we
every
know.
day, every time I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though.
At this point, did she already? I have to. I've got all my days messed up. I don't even remember what day we're watching at this point. When I started working on these videos, I did not do them in order, so it's hard for me to keep up with my days. I have notes somewhere about this, but what I was going to ask you guys is, is this before or after she came out and gave her ruling on subject matter jurisdiction? Because there was a day that she did specifically do that. I think this is after. So we'll see how she responds.
They've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted.
He thinks they're going to dismiss it.
And everything that I'm saying, it has merit and it has validity.
Oh,
As
no,
we
it
sit
doesn't.
here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days.
I know he'd been talking to somebody, and I can't remember, and I know that somebody told me who it was, and honestly, I've forgotten already. Was this the stuff that his mom sent him a bunch of junk in jail? Or, yeah, I think so. I can't remember who it was. Or was this the one where we were suspecting that it was that other guy, that um, uh, Jay Prince guy that was giving him information? But see, that Jay Prince guy's not real smart. So I don't know. I don't know where the hell he's getting this. Maybe it's a.
There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet.
Oh my word.
There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over.
Trampled.
No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing is certified that I get copies of when I.
Well, they have to be legitimate, Darrell, for them to be, acknowledged.
I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding.
Recuse.
At this point, if you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter.
Which is why you should have
and there's still
stuck
no
with your
verified proof.
attorneys.
Like, even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal, factual basis that can state why this information has why the docket
No, but there's several hundred witnesses.
sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury.
You know what? Have you ever heard the term that sometimes information in the wrong hands is dangerous? Are you guys getting that vibe about now? Because I am.
I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I
You know what would be superb if after that happened, all of the injured parties, including photos, those large photos that they carried at the parade of the following year of the people that had passed away, and then the people of all the people that were injured, they couldn't fit them in their dadgum room. They couldn't fit them in their courtroom. But if they attempted to do that and said, "Here's your plaintiff, you stupid, stupid little man."
asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything, which you stated for the record a non-responsive answer. A non-responsive answer is an agreement, which would be a tactic agreement by you, Your Honor, that you don't have to answer these questions that you should be answering.
Tack it.
I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party.
You know, it'd be funny if they did it like they shot back and they did a picture of Dorow about now, and she's sitting there following her nails. Because that's what I'm doing.
Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in evidence.
No one has claimed to be an injured party? Does he not? What? Do you guys think that in his mind that he really believes that? I think he does. I truly believe. I think he does.
Any unrevealed contract. Has that been provided to me? Has that been placed in the evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know?
Oh, they have the full picture.
They
honey.
ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of.
Did this guy not ever watch
It's
Law and
our
Order?
right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf.
Well, they did try to get the paperwork organized for you, and they probably gave you what little bitty chance that you did have. No, you really didn't have a chance. But they did get that paperwork ready for you.
I haven't, in fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney.
Yes, we all
In
know
fact,
that.
the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year.
Okay, and right here I want to rewind.
So we are here, Mr. Brooks, we are here because you want to represent yourself.
Yeah, but I didn't file the motion.
Once,
Can I ask why would it be challenging?
when a person represents themselves, they are acting as their own attorney. Did you hear me say that?
Yeah, I don't agree with that.
Of course, we have a form in Wisconsin. Mr. Brooks, I do have in front of me a waiver of right to attorney form that was electronically filed into the case. Your attorney placed in front of you the original waiver of right to attorney form that you filled out. There's a signature box that has a number of lines, and there is one line where it says name printed or typed with the name Darrell E. Brooks typed in. Do you see that?
I see it, but that is not the way my name is. I
Sir,
don't acknowledge
do you
that
acknowledge, just listen to me, sir. Do you acknowledge that when you received the form, that printed name was on it?
I recognize that there is a name printed on it. That is not mine.
Sir, the form that you have in front of you, which has a lot of other information on it, did you fill that out?
I filled it out a certain type of way.
Listen to me, sir. Did you provide the handwritten information on this form?
Yes.
Have you been informed, sir, regarding the total exposure if convicted of all counts as charged across these 77 counts?
I am informed, yes.
Sir, did you hear what I said?
I thought I was following the sheet. That's why I'm looking
Sir,
at it.
did you hear what I said?
Oh, I did not hear what you said.
Sir, are you informed that all of the charges stemmed from conduct that is alleged to have been committed by you on November 21 of 2021 in the city of Waukesha?
I'm informed.
Are you further informed that all of this conduct primarily relates to what has been referred to as the Waukesha parade incident?
They worded it as a different way. They call it an attack.
I don't know who they is, and I don't frankly care. The next section of this form is titled, I understand an attorney would. However, on the form that I have, the word understand is changed to am informed. Do you see this section of the form, sir?
Yep.
Did you change the word understand to am informed?
Yes, I did.
On the form that I have, there is a line underneath that says, check this box if you have read and understand the above. The word understand has been crossed out and changed to am informed of. Do you see that?
Yep.
The box is not checked. Do you see that?
Yep.
Was that an oversight?
No, that's a reason.
I'm sorry, I didn't understand what you just said.
There is a reason.
Do you Sir, I advised you of what an attorney would do. Are you informed of what an attorney would do for you?
Yes.
Why did you not check this box?
Because it is my understanding that representing myself pro per, I can have standby counsel. So that, in a sense, is why that box specifically is not checked.
That is not a correct statement of the law, sir. This court, sir, you should be advised, would not be appointing attorneys Perry and Keyes to represent you, or to act, is a better way of saying it, as standby counsel in this case. Did you hear what I said?
Yes, and I didn't ask that. I didn't ask for them.
I'm not asking if you asked that, sir. I'm giving you advisements right now that you need to listen to. This court would also not appoint standby counsel in this case. Did you hear me say that?
That's fine.
This court is further advising you, sir, that this trial will start next Monday, October 3rd. Did you hear me say that?
I heard you say it, but I object to that. And I object on the grounds that, are you making a judicial determination of that when you haven't even decided the issue while we're here?
So I'm further going to advise you that at this late stage in the proceedings, which is frankly beyond the 11th hour, which is what the case law references, we are frankly at 11:58. This court will not appoint any other attorney to act as standby counsel if this court grants your request to represent yourself. Did you hear me say that, sir?
Is that the answer to the question?
Sir, did you hear me just now?
Is that an answer to the question?
This is not a question and answer session, sir. I'm giving you certain advisements. Did you hear me advise you just now?
Did you hear the question I asked? Because it sounds like a
Mr. Brooks, we'll move on. You are advised that, Mr. Brooks, you are advised that this court will not appoint standby counsel.
Okay, you said that.
There are a number of reasons which I will advise you make it impractical. This trial is scheduled. Mr. Brooks, do not interrupt.
That is a rush
Mr.
judgment
Brooks.
if you don't answer the question.
So we are here, Mr. Brooks, we are here because you want to represent yourself.
Yeah, but I didn't file the motion.
That's not relevant, sir. The motion is before me, and I'm going to address it. Stop talking over me, Mr. Brooks.
Just merely asking.
I need to get through the advisement.
And I would like to know the answer to the question.
You are being difficult. You are not listening. You are trying to interject irrelevant factors for this court.
It has
so
merit.
Stop.
It's not irrelevant.
Stop.
I have a
Mr.
constitutional
Brooks,
right to
I'm
be able to
going
ask
to
questions.
continue. Please stop talking.
So it is a rush to judgment.
Mr. Brooks, the case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation while simultaneously exercising the right to counsel. Did you hear me say that?
Yes, I heard you say that, but that wasn't what I was attempting to do. That was the whole reason why I said it was filled out. This form was filled out for a specific reason, the way that it was.
Sir, I'm not going to entertain a request for whether it be called standby counsel, hybrid representation. Your attorneys have told me you want to represent yourself. That is why we are having this hearing here today. The next section of this form is entitled, I understand that if I represent myself, but on my copy, the copy e-filed in this case, it says, I am informed that if I represent myself. Do you see that section, sir? It's on page 2. Do you see that?
Yes, I do.
You are advised, sir, that the judge, that's me, cannot be your attorney and cannot give you any legal advice. You are further advised that the district attorney cannot be your attorney and cannot give you legal advice. You are further advised that the judge, district attorney, and court personnel are not required to explain court procedures or the law. You are further advised that the judge cannot treat you any differently because you do not have an attorney. You are further advised that you will be required to follow all legal rules and procedures that an attorney would have to follow in court, and that it may be difficult for you to challenge evidence presented by the district attorney if your case goes to trial. You are further advised that it may be difficult for you to present evidence. You are further advised that if you want to testify, you must be sworn as a witness and answer questions from the district attorney. You are further advised that it may be difficult for you to do a good job as your own attorney. Did you hear the advisements that I just read to you, sir?
Yeah, I heard.
You are further advised, sir, that acting as your own attorney may be very challenging. You would be required to participate in jury selection, including exercising preemptory strikes. It may be difficult for you to raise the issue of strikes for cause. At trial, it may be difficult for you to raise objections, both when to make them and how to make them, whether it be as it relates to the admission of evidence or the testimony of witnesses. Other obstacles that you will face include applying the rules of evidence, understanding and applying the rules of trial procedure, These are things that are spelled out in the Wisconsin statutes. They're the law. You may face challenges when it comes to jury instructions, including when or whether to ask for jury instructions on lesser included offenses. Did you hear me advise you of these challenges, sir?
I did hear you advise me of them. I don't see them as challenges, Your Honor, at all.
The court must also advise you that I can make no guarantees about your access to legal materials while in the jail. Did you hear me advise you of that?
Yes, I did.
When a person represents themselves, they are acting as their own attorney. Did you hear me say that?
Yeah, I don't agree with that.
The case law says that rescinding a waiver of an attorney is no different than a motion seeking the substitution of an attorney. That is why this court is advising you it would be challenging for this court. I didn't say impossible, it would be challenging. There's a reason I'm telling you, sir, about some of these challenges and difficulties, and that is because I want you to know that waiving your right to an attorney does not mean the trial is delayed. Did you hear me say that?
That's not my reason for wanting to represent myself pro per. It had nothing to do with delaying the trial.
So you don't want to delay the trial, correct?
That's not what I said. I said that the decision to represent myself pro per had nothing to do with a delay tactic. I think I'm very clear with what I said.
Well, I want to be clear. I understand you, sir. If it's not a delay tactic, I take that as you're not requesting an adjournment of the trial. Is that true?
That's not what I said.
Are you requesting an adjournment of this trial?
I can't logically make that decision until you make a judicial determination. Why would I answer that question right now at this point when I still don't know what's been decided yet?
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
I heard you say that. And I still can't logically answer what you are asking me because a decision has not been reached.
So what you need to understand is that the case law makes it very clear you have the absolute right to represent yourself. That is protected by the U.S. and the Wisconsin Constitution. Did you hear me say that?
I know that.
It is my understanding, sir, that based upon the motion that was filed, the waiver of attorney form that was filed, and the proceedings that have been held over the course of the last 2 days, you wish to represent yourself.
I wish to represent myself pro per, but I do not wish that my entire Sixth Amendment right not be honored. I essentially would only be agreeing to the part where I want to represent myself. Just that stipulation of my Sixth Amendment and no other stipulation of my Sixth Amendment.
Your Sixth Amendment right to counsel is pretty straightforward, sir. You have the right to an attorney. You have the right to represent yourself. Those two things don't always go hand in hand. In fact, never go hand in hand. The use of that phrase by you, sir, is a clear indication to this court that you want to represent yourself without the assistance of an attorney. Did you hear me advise you of this just now, sir?
Yes, and I'm aware of that same definition by the Black's Law Dictionary.
Sir, it appears to me that you read through this form very carefully. Is that true?
Yes.
You clearly changed words on the form, right?
Yes, for a reason. Where I put please elaborate first on one of them. That was the only thing that I had a question of.
Sir, I cannot give you legal advice. What I can tell you is you are required, if you represent yourself, to follow the rules of evidence, the rules of procedure that are spelled out in the Wisconsin statutes no differently than if you were an attorney.
If I was a licensed attorney, which I'm not, which means that would be pro se and not pro per.
Sir, they mean the same thing. I don't frankly care what you call them. The terminology you use has the same effect. You either have an attorney or you do not. Did you hear me say that?
I'm aware of that.
There's another paragraph, and it appears to me that you read it and that you changed the word understand to am informed of or on. You see that?
Yep.
Sir, anyone make any threats or force you in any way to sign this document?
No.
Anyone make any promises to you in exchange for signing this document?
No.
You understand, sir, that by signing this document and presenting it to the court, you're asking me to accept your waiver of the right to an attorney.
Just so I'm clear, that would be essentially just that part of my Sixth Amendment, correct?
The right to an attorney, yes.
Just that part.
We are just talking about the right to an attorney, sir.
So essentially the rest of my Sixth Amendment right is preserved.
That is correct. Sir, do you wish to waive your right to an attorney?
Yes. I think you were pretty clear in what you advised me of. I think you made it very clear that it would be challenging, but not impossible. That was your exact words, verbatim. So what needs to be made abundantly clear when you've already done that?
We talked some yesterday about some of the challenges. You would agree with that?
As far as
representing yourself. And I'll be a little more specific. Yesterday, I went through the experience of not only your own attorneys, but the experience and the resources available to the state. Do you remember that?
I do.
I may not have said it this way, but one of the things the state will be able to do is there are 3 attorneys seated at that table. They can divide and conquer the work between them. Did you hear what I said?
Yes, ma'am.
You're fully informed about that, correct? And I'm going to I know you don't like this word, but you understand you're going to be sitting at that table by yourself, right?
I'm not alone, I don't think.
There will be no attorney seated next to you, correct?
I know what you mean. I know what you mean.
All right. You will have the sole responsibility to cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that?
I am informed.
Any questions regarding that?
Not at all.
Do you have any questions for the court at this time regarding this form?
I think you touched on it a little bit on what the question would have been, and that was basically just the stressing that I did of the pro se thing, because essentially, from my understanding, is that pro se, in a sense, because I would be basically like I'm a licensed attorney, so that would kind of limit what I'm able to do versus being pro per. You touched on it a little bit and gave me a little.
Sir, I'll tell you, it doesn't matter what you refer to yourself as, whether it's pro se, pro per, in Priya, persona. You will be acting as your own attorney, and I believe you fully understand that. I want to go back to the box that you did not check, though. Given everything that we've discussed here today, do you have any questions regarding the section regarding what an attorney would do on your behalf? I don't mean you acting as an attorney, but a licensed attorney in the state of Wisconsin assigned to represent you.
Yeah, you touched on it. I think it came up like right when I had voiced that, and you kind of clarified it.
Understanding that this section refers to a licensed attorney in the state of Wisconsin, would you be willing to check this box now? That you have read this section and that you are informed of the above.
Yeah, I'll check. I feel like we've covered everything dealing with that form. I don't understand the relevancy of stressing the form that we just spent so much time going over. I think you were more than clear in your advisements of exactly what the form meant, and I think you were pretty clear.
We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September.
Brought.
Which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days?
Well, it's not like you have anything else to do.
That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes.
Yeah,
When the court is well aware that I was not prepared.
We kind of figured you were winging it. You didn't have to tell us that one.
I raised the issue that it should be an adjournment, at least. At the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor?
Yeah.
Can anyone right now in court, anyone, make a claim against me?
Yep. I'm sure
And
there's some
because of
people
that,
in the
Your
background.
Honor, the motion to dismiss should be granted.
You know what? I give 100% kudos to the family members or victims that were in the court through some of this that held it together and didn't lash out or speak. I probably would have been in the back. I would have lost it at some point and just started yelling at him. And they would have had to kick me out.
Based on that alone, there's no injured. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Because of that, Your Honor, the motion to dismiss should be granted. Based on that alone, there's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal in any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do.
It doesn't make any difference. You can raise it, but this doesn't mean anything. Still going to go forward with the case. What? You know what?
I have the right to specifically reserve all of my rights, which I do at the beginning.
And you guys know that Sue Opper's over there like biting her bottom lip about half off, wanting to say something.
I have the right to say want and to be heard under the First Amendment.
Well, hello.
And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year.
Okay, but a few minutes ago, well, actually, a couple of sentences ago, you said that you felt like it was impossible for you to be able to get all this stuff done in the time that you were given. And now you're saying speedy trial. This fool is just grasping at straws.
I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and
So, do you want a speedy
I
trial
still
or do you
don't
want to wait?
understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day, every time.
How many of you guys are out of the United States watching this? Because I know for a fact that Miss Charlotte is from France. I don't think they would have moved this to France. I'm just saying.
A political campaign was brought up, it made reference to this incident every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to I don't know if it was to you becoming a judge, or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional relationships is and personal relationships. I've never had.
Did he just say he's worked numerous jobs? Oh, Darrell. She works in a professional position, Darrell. She's not moving stuff around in a warehouse or whatever it is that you were doing. What was it? What did he say he was doing? I forgot. Something he was having to pick up stuff and move it around. Yeah.
the cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something. That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for
Check your
the
notes.
evidence motion that I raised, that was denied without any explanation. That would be strictly to placing the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that.
You know, he's sitting in a room full of attorneys, spent years in law school, including the judge, and he has the nerve to talk about all this, to school them on this stuff. At some point, I would be like, it's time for him to go. Somebody grab his coat. This punk is history, because it really is. At this point, this is ridiculous. Judge should have shut him down already. And y'all know I'm a big fan of hers, but
There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right.
no.
That was it. That
No.
doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this.
You shouldn't have represented yourself.
But I still complied to what the court asked of me. And even then, there's a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case?
Whew.
So how could the subpoena not be filed, and how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a Detective Casey, that got on the stand and said on the record that it is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the
Oh no, they're there. Trust me, they're there.
claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about.
There's no way he believes that that's true. You guys, there's just no way. See, there's a total disconnect in what this man did. I can't, I'm sorry. There's a total disconnect in his mind on the aftermath of his actions. I don't, I don't have any other way of understanding it. I can't understand it.
Jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor.
He's run out of stuff to say. He starts repeating himself because they're just sitting there going, go ahead. Go ahead.
Why was I not provided with a certified copy of your oath of office? Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it's not certified. So how can I verify that that is the true oath of office that you signed? How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you would not do that. You never stated any legal reason why. I have the right to ask for that legally.
And you have. And we heard you. I think he's
I also
done.
have the right to call any witnesses to assist my defense.
Somebody call him an Uber. I just think it's time.
Which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design, from my knowledge,
Which isn't a lot.
the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant? You also know that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change?
It's a
I still
conspiracy.
have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here. Every time. You bring the Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case. Nowhere does it say you can create a 4th option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason.
Oh, he said that twice, and the second time really loud.
You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about are you making judicial determinations, I'm repeatedly shut down.
All right, I'm going to check the time clock. How long have we been doing this?
Which leads.
Okay. We're 37 minutes in. I think it's a 50-minute rant, so we got about 13 more minutes of his BS. Should I fast forward? I think we deserve, well, we don't deserve it, but I think that we should be thorough and listen to the whole thing.
To
Frankie,
today.
what's wrong?
The constant push not to have an informed jury. Not giving legal valid grounds on objections, not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instructions you informed them that the state of Wisconsin was bringing the claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense.
How does that bailiff behind him keep such a stern? I mean, just no reaction. At some point, he's just. Maybe he's playing Sudoku in his head.
You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait till the next day. That's a clear bias and a clear prejudice to my defense. Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations
Make his coffee in the morning. He wants a secretary.
to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement.
Okay, let's take a pause because he's brought this up just way too many times, and now I need to jump back. We're going to go back to the very first day that, well, no, it wasn't the very first day. We're going to go back to the day when Mr. Brooks informed the court that he was going to be representing himself. And here's what was said.
But yet, I'm still forced to come in here with zero help. I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion.
The entitlement. Oh.
It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per Jail Administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day. Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to
Did he say library?
describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that
Oh, yes, he did.
when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case?
What about that big old box of files? I'm sorry, those big old boxes of files that you have there.
How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need.
Oh, now
Now
he's going to tell him how to run the jail.
Courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude.
Hell, they should have shut down the entire state and everybody should have just stopped what they were doing to help him with his case. What were we all thinking? Where have we been? We totally missed that boat.
Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet and still, that was it's impossible for an impartial jury to be found in this county, and that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That wouldn't be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this.
Don't forget about us on YouTube.
The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said.
Are you guys being insensitive again?
The
Stop
sheer
it.
insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's the truth.
No, we don't care.
The fact of the matter is, that I have children too. Family too, loved ones too.
Oh, don't bring your children up. We already know all about that.
That also have been ridiculed and had their names drugged to the mud and have threats towards them.
Maybe you should have thought about that before you did what you
Loved ones that had
did.
to leave their home because they were getting threats thrown through their mailbox. Children that didn't.
He says this stuff like it's our fault that this is all happening. Like he had no. It's just all happening to him. Everybody's against him, and he didn't do anything to make it happen. I'm telling you guys, what's in his head, I don't understand.
Feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever. To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy. Definite. And that will never be swept under the rug. There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about.
He created the victims. Every single one of them, even the ones in his family. What did you? Oh, I need a drink.
And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive, and it's not true. I'm sure the court read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions. I think it was obvious that the venue should have been changed. Obvious.
Didn't we already talk about this?
It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero. There's so much bias that's going on that
He's looking at his notes again to make sure he didn't miss anything, to say it again for the third time, because he might have only said it like twice.
and even with all this, for the record, we still have no proof of jurisdiction. We still have no bond on file in the docket sheet. We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship, no matter how well prepared the speech was. Because it was a prepared speech. That was obvious. Where's the proof?
Okay. So if there's anybody listening that's really hasn't been ever paying attention to this trial, and I don't know, maybe you've been out of the country or on another planet, let me ask you, and please drop it in the comments section. Tell me, please, do you think what he's saying here is going to make any difference whatsoever in his trial? Just wondering, what do you think the reaction from the court's going to be? Oh, and by the way, do you think he's guilty? And oh, by the way, do you think he's going to be found guilty? Now, again, I'm just talking to people that, don't know anything about this trial. I'm just saying. You haven't been watching it. You have no idea, because there actually could be some people out there that just don't pay attention to this stuff. Believe it or not, we eat, breathe, and sleep it, but not everybody does. Just curious. Have you ever seen anything like this in any other court case ever? I don't remember the Ted Bundy case. I'm trying to think back. He got up and talked a lot, but I don't know. Obviously, he knew what he was talking about, though. Big difference. I don't know. If you can think of one, let me know.
Just ask that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case? There still is no proof. If you hold the full judicial power of the state, or is it the military?
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response. Go ahead.
Thank you, Judge.
Yes, she does.
Judge, I'm going to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last
I'm
one?
so sorry. 3045190. Retzloff versus Moran.
Sue's fired up.
This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. And the court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly
consent to being called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial. He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my, he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, You violated his rights because it's taken us so long to get to trial, and on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. You warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials, but he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap.
Mr. Brooks, that's my opportunity now. I gave you about 50 minutes.
I just want to object to the disrespectful comments that was just made. I'm not trying to hold you up from what you're gonna say, but that's a load of crap.
Mr. Brooks,
for her to sit there,
Mr. Brooks,
for her to sit
your
there,
objection is noted.
for her to sit there, Your Honor.
It's my turn. Let me go through this.
My turn.
Graciously gave you 50 minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I am going to render a decision at this point. Please listen, and please do not interrupt. As I indicated, the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative, without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors. There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. Then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive. They come to this court, as the case law says, there's a presumption that they come to the court without bias, and it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further.
Woo!
The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201, which requires that the basis for the relief being requested be stated with specificity and be based in law and fact.
He's like, okay, what was that? 802 or what?
The vast majority of the points that you raise, sir, are issues that you can raise on appeal. It is true. You have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted. The record is going to be very clear. All right? I have a court reporter who's taking down the record of everything that is said and done in this courtroom when we are on the record. And so I don't have to all the time say it's noted for the record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case. Aware of the state wanting to do that. That is the first time any such issue has been raised, and I see it as a distraction and as simply a statement made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge was assigned to this case, and your attorneys on your behalf exercised that right of substitution. So to say that you have the right to seek recusal at any time would be a misstatement of the law. And even if you think that should be exercised or there is a valid claim for that, sir, it's not been raised in the proper way before this court. This trial will keep going.
Yes.
I still expect the basic rules of civility and decorum to be followed. That includes, sir, that when there is an objection to a question that you ask, that you wait for the state to indicate their objection and the basis for it. If I need additional information, I will ask for it. If I don't need additional information, I will rule on it. And I do expect that even if you disagree with that ruling, that you will abide by it and that you will move forward. Whether that's asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum, and that's you not interrupt, and then you follow the rules of procedure. As far as the other issues you raise concerning your right to assistance of counsel, the record before this court over the many days that that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is required by the Constitution of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law.
You know what's kind of cool about what she's doing right here, or, about her situation, is that very rarely, I guess nowadays it's getting more common, but very rarely can she say, yeah, it's on film. Not only do we have it on the record, it's on tape too.
Both case law in the state of Wisconsin and case law from the 7th Circuit Court of Appeals, which not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited. United States ex rel. George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 30451. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise. But those sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter into, regarding admiralty court, etc., they're baseless, sir. And this court need not address them further. Now, with that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time. So I'll instruct Madam Clerk to bring the jury out.
For the record, Your Honor, we didn't bring up the Higgins-Levine 415 U.S. 533 decision. That was not addressed, and the issues are still not addressed. There's still been no proof
Oh my gosh.
to anything that you said, anything that the prosecution has said. There still
my
hasn't
Objection
been.
is noted, and we will continue. Bring the jury out, please.
There still hasn't been
Mr.
any
Brooks,
proof.
I've addressed them
There
to the
still hasn't
extent that
been
I
any
will.
proof. There still hasn't been any proof. I never once. The comment about me not flinching was when you said that there's 66 years of experience at that table. That's the comment I said, that doesn't make me flinch. That was mischaracterized. That should be for the record. There's still been no proof.
Mr. Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's
It's
anything
not.
along those lines. It is frankly not required under the law.
Do you think he doesn't know how dumb he looks?
You may disagree with that. You can take that up on appeal, whether that's an interlocutory appeal or whether that's a direct appeal if there is a conviction. But I'm not going to address it any further.
Because there's no verified proof.
There does
Oh my
not
gosh.
need to be, sir. All right, I
It does
believe the
need to
jury
be.
is coming out. Is that true, Madam
In
Clerk?
order for a case to,
All right, the
To
record
go
should
on, there should
reflect
be
that the
proof.
jury is coming out, and we are about to continue with the state's next
not once
witness.
was the plaintiff addressed. That wasn't addressed.
I bet the jury's pissed.
Where's
It's
the
down there
plaintiff?
so
Where's
long.
the injured party?
Oh my gosh.
That's because
The jury will disregard the statements presently being made by the defendant.
Because y'all don't want the jury to know the truth.
The jury will disregard those statements
I understand.
made by the defendant.
I see.
It is not his opportunity to testify. They are comments, and as such are to be disregarded.
I see what's going on.
He sees what's going on.
Don't work.
All right. Thank you,
gonna
everyone.
work.
You may be seated.
It's not gonna work.
Attorney Opper, you may.
Evans.
And you know what? He said it's not gonna work, but you know what, y'all? It worked. Because he's in jail for 1,000+ years. Plus. Woo! That's a long one, huh? But you guys wanted it. Somebody asked for it. Um, I it's I feel like he basically just stole time from everybody in that room, including us. It's so ridiculous. And then they sat there and gave him these long, drawn out responses because they did their jobs. They made their notes while he was talking. They came back and they gave him answers to all of it. They addressed it all. And he still, like a 2-year-old, ignored everything they said in one ear out the other. Unbelievable. Unbelievable. All right. If anybody knows what's in his head, tell me now. At this point, it's probably already been put in the comments. I know. Uh, I'm not gonna do a poll. I don't think I am. If we'll see. I don't know. Maybe we do a poll in this one. I could have already put one up at this point. I don't. Who knows? I'm not tomorrow yet. I'm not there yet. um, so tomorrow I'm trying to do another school of law. So I I just I already had this piece put together, and it was just easier for me to do it this way. And honestly, there was nothing funny about what we just did, but yeah, I've got a couple of funnies still left. I'm trying to weed them out, and I honestly think I still have footage I haven't even watched yet of that trial, not since it originally aired. So, oh my, oh me. I like it though. I'm having a good time going back through it. So I hope you guys are enjoying it. I really appreciate you guys allowing me to spend the evenings or afternoons with y'all as we do this together. And I hope you enjoy our little chat community. I think you guys we have an awesome little community going on right here. And I will see you guys on the next one. If it's not tomorrow, it will be Friday that I drop another one. Y'all stay blessed, and I will talk to you soon.